Thank you, Philip. Um, like Philip, I'm also up here without perhaps the best preparation, but we shall go ahead. Unfortunately, I don't have the ability to choose whether or not to use the PowerPoint slides. That direction comes from on high. So you'll have to sit through Datuk Sundarraju's slides, I'm afraid. But just to build on what Philip said earlier, not just going to be looking at Asia, but looking at Asia relative to the concept of a seat of arbitration. And given some of the issues that we've already discussed this morning and this afternoon, what are some of the issues that we need to look at when we are considering a seat for arbitration? What are some of the considerations that perhaps traditionally we've not had to deal with, that traditionally we've not perhaps had an answer for, that we do now have an answer for? And I suppose the cover slide sort of gives away the answer to that, but the answer to that is, in fact, Asia. Right, so what we'll go through in this presentation, we'll try to keep it brief so that we can focus more on the discussion. But what is the concept of a seat? I think most of you in the audience are probably already well aware of that, but it's important to really understand the fundamentals of what a seat is to understand the significance of the seat and why we're actually having this session. The reasons to actually break away from the traditional seats of arbitral proceedings, we've discussed what some of the traditional seats are, mostly in Europe and North America. The impact of sanctions on arbitration and the need for alternative seat. Right, again, we've already discussed in some length what the impact of sanctions are, but perhaps not specifically relative to the need for an alternative. Looking at the popularity of Asian arbitral institutions, something that is on the rise recently, and is something that perhaps some of the countries that are subject to sanctions can really look to and to take advantage of. So specific reasons why Asia can fill that void, steps that have been taken so far to meet that demand, and of course we finish off with some of the challenges that we might face moving forward. Right, so again, I think most of you are well across this, but the concept of a seat is, in essence, it's the juridical home of the proceedings. Okay, the seat will give you the procedural law. So for example, proceedings that are seated here in Malaysia will be subject to the Malaysian Arbitration Act 2005 as revised in 2011. Conversely, proceedings that are seated in Sweden will be subject to the arbitral law that is applicable there. The importance of this, of course, is that procedural law will give the procedural base of the proceedings. Okay. Most importantly, when you're looking at setting aside an enforcement, in particular setting aside, that will often come down to the law of the seat. Indeed, it should almost always come down to the law of the seat. There are, of course, always exceptions, but predominantly that should be how it runs. To be successful, international commercial arbitration depends for full effectiveness upon the support of different systems of law. All right. That, of course, as we've heard already from Dr. Yuroslav, law of the seat, the governing law governing the arbitration agreement. Okay, but in terms of procedure, it's the law of the seat that is most important. And of course, parties can choose. Okay, you can choose where you're going to seat your arbitration, and that will have a significant effect on the running of the procedure, but as well on the ultimate outcome of the award once it's been rendered. So looking at a successful arbitration marketplace, there are a number of things that you need to have. Of course, you need to have a strong law. Here in Malaysia, we have the Arbitration Act, which is modeled on the model law. I'd say it's probably about 80% model law. Supportive and sophisticated judiciary. Okay, here in Malaysia, again, we also have a very strong judiciary. I think it's also, it's important to note that it's moving actually from, it's moving away from just being a blind support of arbitration, which I think was something that was popular, sort of a decade ago, and it is reaching now to a level which I think Singapore has been one of the leading jurisdictions in actually understanding and developing arbitration law. Okay, so not just offering blind support, but trying to further it through the efforts of the judiciary and what they can offer. New York Convention status. We heard earlier that 155 countries are members of the New York Convention. It's crucial that the seat that you choose is also a member of the New York Convention. And of course, the strong presence of an arbitrary institution. Okay, it's not always necessary that you run the arbitration through the institution, but having the support of an institution in the jurisdiction, if for whatever reason parties unable to agree on an arbitrator, for example, or some other part of the procedure has fallen down, the parties can always rely on the institution to step in and offer that kind of institutional support. All right, so traditionally, what are the criteria that parties have looked to when they're selecting their seat? Neutrality, of course. Arbitration is something that has come to prominence on the back of cross-border trade. Right? Anytime you have parties coming from different jurisdictions, neutrality is a very important concept. Sophisticated legal system with highly trained legal and other professionals. Okay, not just the lawyers, but looking at experts as well. We were here yesterday discussing Islamic finance, for example. Malaysia has the Sharia Advisory Council, so well-trained professionals that can assist in the efficient and proper outcome of the arbitral proceedings. Independence and quality of the courts. I think I've discussed that briefly already, but of course independence is very important as well. Availability of quality arbitrators and experts. This is something that is becoming easier, I suppose, with the proliferation of institutions across the world. So here in Asia, our panel is, I think, over 900 now, probably 3/4 of which are international arbitrators. And you'll find the same arbitrators on the panel whether you go here, Singapore, Hong Kong, all high quality, very experienced arbitrators. And then, of course, cost effectiveness, efficiency, and expediency. Okay, depending where you go, you're going to have different levels of each. I think KLRCA, for example, prides itself on being a very cost-effective center. SIAC, for example, I think comes in as a more premium level service. So looking at the different kind of disputes that you can service and what that allows you to offer the parties. All right, so the traditionally favored institutions, I think we've discussed them at some length already today, but institutions like ICC, like the LCIA, traditionally they've been the most popular for a number of reasons. Predominantly that they were at the forefront of developing arbitration law, and of course you've always had many of the eminent arbitration experts hailing from those jurisdictions. All right, so I think we've covered the effect and the consequences of sanctions and what sanctions actually are at some length, so I'm not going to harp on that too much, but we have established that sanctions do have significant effects on arbitral proceedings, on the procedure itself, as well as the substantive. It's not limited to one or the other. All right, so there are a lot of considerations that parties need to take into account when looking at a seat and a suitable seat within which to actually host their arbitration proceedings. Okay, we've heard of examples in Iran with the ICC, we've heard of examples in the OIC coming to KLRCA. These are not simply academic theoretical problems. These are real issues that are faced by parties in many jurisdictions. All right, so I think Russia is probably the most recent example, and Russia being such a large economy and a large jurisdiction, I think is one of the things that has brought this issue into the limelight. Even though Russia is by no means the sole party that is finding itself subject of these issues, we do find on the back of it that a lot of different regions are now taking notice. It's no coincidence that KLRCA is having a sanctions conference now, for example. All right, so how do the sanctions actually impact the arbitration process itself? Of course, the choice of governing law is one that we covered already. Okay, so looking at whether the choice of governing law imports certain mandatory provisions in relation to sanctions and what effect that might have on the procedure and on the merits of the dispute as well. All right, we've looked at arbitrators with citizenship from the country imposing the sanction. What effect is that going to have on whether they're able to actually be paid? Enforceability. Of course, there's no point in having an award if you can't enforce it in the end. Something that's very important for parties to take notice of at the beginning of the dispute. Travel, other embargoes. We went to some great lengths here in Malaysia to ensure that foreign counsel and foreign arbitrators, for example, do not have any visa requirements. They're able to actually come into Malaysia without the need for any immigration pass in order to conduct their proceedings. Okay, and it was a multi-stage process. At first, there was the fly-in, fly-out provisions. Okay, so they're able to come in for a total of 60 days during the year. But we've since been able to even take it further. There are now no restrictions on foreign counsel or arbitrators when they're coming in for arbitration proceedings within Malaysia. Okay, so it's very important, these kind of considerations when parties are choosing seat. and sanctions have the opposite effect. And of course, difficulties in making payment, collection, and deposits of award. Okay, so we've heard of the difficulties that can arise, when a tribunal is looking at collecting fees, something that might seem so simple, especially to us who are, managing cases here in the KLRCA, can become such an issue when sanctions and political interference is involved. All right, so why Asia as a preferred seat? I think before we can look at why Asia, we need to look at perhaps why we are actually able to look away from the traditional seats. Why are we able to now make this choice? A lot of the things that have traditionally made strongholds like LCIA, like ICC so strong, are now actually available more or less all around the world. You come to Asia, you're able to get the same quality of arbitrators. In essence, a lot of the arbitrators are probably coming from the same place. The rules, very similar, okay? Institutions are very quick on the uptake now when international best practices are established. For example, emergency arbitrator provisions. It's no coincidence that, KLRCA in Hong Kong, for example, brought out emergency arbitrator provisions, I think, within 1 month of each other. All right, so we are now in a situation where, globalization is very harmonized, looking at arbitral procedure. You don't have to go to a traditional seat in order to get the best service. All right, so, which brings us, of course, to Asian arbitral institutions and Asia as a seat. Okay, so looking at globalization, not just from the harmonization of procedure, but the trade and economic side of it as well. Okay, here in Asia, here in Malaysia, one of the big focuses recently has been ASEAN. Malaysia has taken the chair this year, and I think the end of this year sees the implementation of the AEC, which is the ASEAN Economic Community. I think broadly it's supposed to sort of mirror the EU. I have my doubts as to whether it will reach that level or whether it even should reach that level. I think the considerations in ASEAN are very different to Europe. But one of the unavoidable circumstances and consequences of that is that trade, intra-ASEAN trade, will increase. And it won't just increase, but awareness of remedies and awareness of mechanisms will also increase. So as of 2012, ASEAN already has the CIA, the Comprehensive Investment Agreement, which does actually contain arbitration provisions within it already. The issue, of course, and something that I was discussing with Alistair earlier, is that most parties are not actually aware that those provisions exist. They don't actually know that they have those provisions, they have those protections. So one thing that will come with the proliferation of ASEAN and of the AAC is the awareness of these provisions. Okay, and that will only serve to boost Asia as a region that is not only neutral and cost-effective and all these things, but is also a hub for knowledge and for growth and development in those particular areas. All right, so some of the, just to back that up with some of the facts, some of the trends that have arisen in Asia. There's the institutions that everybody knows. Everybody knows CATAC in China, Hong Kong, HKIC, Singapore, SIAC, KLRCA, of course, here in Malaysia. But the proliferation of institutions across the rest of Asia has had flow-on effects as well. So, you look at what's happening in places like Taiwan, places like Myanmar, Vietnam, Indonesia, Thailand, and certainly we've been involved in trying to boost the status and development of arbitration in those regions very closely. I suppose the cynical view is that a lot of these jurisdictions are attempting to build some capacity within their country should they be subject to arbitration proceedings in the future, with how the TPPA negotiations are going. But I think that it's not such a cynical view that these countries are trying to increase the knowledge within their own country. Countries like Myanmar, Indonesia, they don't want to be opening their wallets to international law firms every time an issue arises in relation to investment in that country. It's supremely important that they do build capacity within their country, and that's what they're trying to do now. All right. And that has brought with it also a trend towards regionalism. Okay, so cooperation between the different institutions. Okay, and that's happening to a large extent here in ASEAN, and I think it will also happen outside those borders as well. Okay, so we have a lot of interaction with the Middle East, for example. We've translated our rules into, I think, 8 different languages at present. 7 or 8, I don't know if we've done the 8 yet. We're in the process, but many different languages, including Russian, for example, including Arabic. including Spanish, looking at Latin America. So that regionalism and that cooperation between not just KLRTA but other institutions and other jurisdictions around the world is extremely important, and one thing that really strengthens Asia's stance as a preferred seat for arbitration. And just to give some examples, I won't go into these too much. I don't think this is really so much what we're here to discuss. But Malaysia, I think you've all witnessed firsthand the steps that the Malaysian government has taken, that the KLRCA has taken to develop arbitration within Malaysia. Right. Singapore, I don't think I need to tell you either what Singapore has done in relation to developing arbitration there, not just arbitration, but all forms of dispute resolution. They've got the International Commercial Court that they've just set up as well, the Mediation Center as well, which is doing very good work. Indonesia, so the development of the Indonesian National Board of Arbitration, BANI, that we have been cooperating with extensively in the last couple of months. Thailand as well, they've been revamping their legislation and looking at bringing in a new Thai arbitration institution that will be independent from the government to promote and increase arbitration knowledge within Thailand as well. I think they've left this morning, but we've actually had 2 delegates from the Thai arbitration institution here with us all week, shadowing KLRCA during the week, to learn some of the best practices that we have here, and of course attending the conference. Vietnam, okay, Vietnam's been very strong as well, looking at how they can revamp their own law in line with the model law. Myanmar, I'm not going to go through all of them, but Myanmar, Cambodia, Philippines. I mean, this is really just exemplary of the route that Asia is taking in developing not just the individual seats, Malaysia, Singapore, Hong Kong, but the entire region as somewhere that is really conducive to arbitration with a number of really good, solid choices when you're looking at the seat. Okay, so I think Patricia was right that even though the sanctions are coming in, that doesn't necessarily mean that you cannot still go and arbitrate in Stockholm, LCIA, these areas. But the unfortunate consequence of the sanctions is that many parties, for them, those places just aren't really viable options anymore, as they have been in the past. Okay, and that might just be by preference. Okay, that might be as simple as a company like Rosneft saying, well, if they don't want, if they don't want to give us their money, we're not going to give them our money. It can be something as trivial as that, or it can be more, more concrete, more logistical issues, such as what parties from Iran are experiencing with the ICC. All right, I'm conscious of taking all of Alistair's time, so I think we'll start to speed it up a little bit. But this does raise certain concerns of the legitimacy of the process. You do need to maintain certain aspects you cannot compromise on: impartiality, independence, and it's unavoidable that will become intertwined with the political context, of the procedure. Looking at the sanctions, looking at sort of indirect political interference, the kind that I mentioned with the OIC, for example, not wanting to interfere with with Egypt and antagonize Egypt, and therefore refusing to something as simple as appointing an arbitrator. You cannot really separate the legitimacy of the proceedings from those sort of considerations. So it's something that we need to take into consideration. All right, so what are the factors that parties subject to sanctions or in jurisdictions in the shadow of sanctions, as Ben put it earlier, likely to consider when looking at the seat? So political neutrality and perceived neutrality. And this isn't as simple as it looks on first instance. When you look at neutrality, it's not just current neutrality, but you need to look at a history of neutrality as well. So, Malaysia is a country that has for many years worked to, I think, maintain an air of neutrality towards countries from all around the world, from Islamic jurisdictions, from Africa, countries like Iran, as well as the developed countries, Europe, North America. That history, in essence, allows a country to then maintain that neutrality. If a country like Australia, for example, was to turn around tomorrow and tell the US, look, we're not going to take part in these sanctions anymore, the US would say, well, hang on, we rely on you to do this. You don't, we're going to pressure you to do that. Whereas Malaysia, on the other hand, cannot take part in the sanctions, and there's not likely to be that pressure because it's accepted that Malaysia is a neutral party and is not going to take part. And that's something that is sort of it's a little bit under the water and it might not be something that you think of on first instance, but it's something that is equally important. So protection and support offered by the government of the neutral country. Again, the Malaysian government, I think, is not only supportive of arbitration, but very supportive of neutrality and independence as well. Supportive judiciary, available institutions that provide a viable option. Okay, KLRCA, very independent from the government. We take great pains to reinforce the fact that even though we are called the Kuala Lumpur Regional Centre for Arbitration, we actually have no ties to Malaysia as a state or the Malaysian government. We're established under ALCO, which is the Asian African Legal Consultative Organization. I suppose the best way to think about it, it's sort of like the UN for Asia and Africa, where technically we're a diplomatic mission here in Malaysia, and we have no ties, so we're completely independent, something that, of course, is very important. Respect afforded to those from other parts of the world, irrespective of race, color, and creed. I think this is fairly simple. I mean, of course, that's something that you need, particularly when looking at neutrality and ensuring that the neutrality is affected throughout the procedure by the tribunal, by the institution, by the government, by the judiciary. Accessibility, connectedness, and availability of all facilities, of course. So, when you have parties coming from anywhere around the world, you don't want to have, you don't want your hearing to be derailed by something as trivial as I cannot get a visa, the day before the hearing. So it's important to make sure that even those small things that get lost in the wide theoretic discussions that we've had today are also taken care of. So political neutrality, I don't want to harp on it, but Asia always has been very neutral in this respect. We had Mr. Tony Kevin this morning made light of the fact that we're sort of pushing Russia into China's arms. The reason that can happen, of course, is because China expresses that neutrality towards Russia, and towards those jurisdictions, and that's across all Asia. All right, so issues concerning impartiality and objectivity, unlikely to arise. All right. Countries like Malaysia historically been perceived, and this is what I was mentioning earlier, that historical stance is very important when you look at the perception, okay, because a lot of the time perception is everything. Parties are not going to want to go to a country that they perceive is going to be biased, even if in reality they're not. We've had that issue, for example, discussing with parties from Indonesia. They're reluctant these days to go to Singapore because they perceive that Singapore is biased against them because they lose a lot of those cases. I think they probably 95% of the cases in Singapore they lose. Of course, from a lawyer's perspective, you might think, well, that's probably because your case is not very strong, or you have not an appreciation of the governing law that you're collecting. But from their perspective, their perception is that there's some bias involved. That's something that, especially as an institution, as a seat, you do need to deal with. Okay, so international standards. KLRCA, of course, completely up to date on international standards. I think we had some interesting discussions yesterday about the, when you look at the conflict between international standards under mandatory laws and under the arbitral procedure. I should emphasize the arbitral procedure in Malaysia, through the arbitration law, through the KLRCA rules, if you're arbitrating with the KLRCA, completely up to international best standard. Depending on whether or not you consider the ability to appeal a negative finding of jurisdiction to be international best practice, but that's something that, as Lam pointed out, we're developing as well. So even the detailed issues we are considering, the judiciary is considering and very cognizant of those those issues. Supportive judiciary. There's a number of cases. I'm not going to sit here and lecture you about the cases, but I think it's safe to say that the judiciary in Malaysia is extremely supportive of arbitration, and we're coming to a point where we have young judiciary that are very understanding of the arbitration law. I think I've mostly covered the other stuff in here. Experts, of course, steps adopted, I think we've discussed already. So in the interest of showcasing Alistair and getting to the interesting part, which is the discussion, might just tell you about the steps that have been taken. As you can see, KLRCA is, of course, taking steps to try and increase the connection with jurisdictions across the world, including those that are affected by sanctions. It is very important, in our consideration, access to justice is something that we take very seriously. Making sure that parties have access to the rule of law, without being impacted by the decisions of politicians, the decisions of governments that they are in essence, they're in their shadow. And if we are in a position where we are able to offer that to the parties, then we're more than happy to do so. And that's just not KLRCA, by the way. That's something that's reflected across Asia. All right, so I think challenges are something that we can perhaps discuss afterwards in the discussion session. But yeah, so thank you very much.